Skylar?
Well, it is 8:30 and I'm gonna turn my phone down. I'm gonna call this meeting to order for September 24th. And Susie, Chauncey's here, Elizabeth's here, Bart is here. John is here and Bart's wife is here. Christie's here. Abby's here, Joe's here, and I'm here, and you're on the phone.
Yeah,
Not feeling too peachy keen.
right.
So
Do you know, was Skylar gonna attend?
I got an
Or
email that
did
said
he-
he was out of the office till the 26th.
I just didn't know because I assumed that he got the red line copy. I just didn't know if he had any thoughts or concerns about it.
When I sent it and it came back, says I'm traveling, I'm sorry. Thank you for your email. I'm out of the office traveling for client matters through September 26th. I will respond to non-emergency.
I saw
emails.
that, but he has responded in the past
Okay.
to them, but I just didn't know. Did you hear anything, Bart?
No.
Okay. So I'm not sure how he feels about the changes or if he wanted to, I don't know. But I'm happy to explain if you guys have any questions.
Well, I think they're self-explanatory and I agree with the changes. I don't personally have a problem with the changes. There's nothing that I see in there that is
Okay,
out of the ordinary. After all, in his original document, he does state that we are the client, legal services to Jefferson County, which he puts in parentheses, client. And so your comment or your statement, that the confidentiality exists between Jefferson County and the firm is correct because we are the client.
right.
You referenced Iowa code. Both AEF and 331.756. And when I talked to Bart, I had some concerns early on about the transcripts and stuff, and they talked, and that's why we hired Mr. Thomas.
Right.
And so all of that information should be prepared, in my opinion, by him. But irregardless, as I explained to Bart, there is a $5,000 cap.
Okay, that was one of my questions. Is that the cap on the attorney services or is it a cap on everything? Just because I saw that there were other, like legal assistant, paralegal assistant. So I just,
Well, my comment to
Fees,
the
so
paralegal was, if he uses a paralegal for 10 hours, that's $900, that leaves him 4,100. It's a $5,000 cap, which is what
Okay.
our motion was.
okay. And I didn't see that reflected in the contract, so I didn't
He
know.
had, let's see, what page was that?
Did I miss something?
Well,
I saw that client has approved up to a total of 20 hours of attorney services. So
Yeah.
that's why I was wondering if we're
Yeah.
saying,
somewhere in here, if I can find it.
okay,
Let me see.
I thought it was spelled out in.
is it?
I thought it was. I'm
Perhaps I
looking
just
too.
didn't see that.
Or did I just assume that through our conversations?
I just wanted to make sure that was clear. If it was, you were capping attorney services at that specific rate, or you were capping all of the firm total costs.
My first oversight, I don't see it.
No, it was there. I can. There's the. Because they did state that attorney will not incur transcript expenses without communicating the Jefferson County Sheriff and confirming the need for said transcripts.
I don't see it, Elizabeth.
I just wanted to bring everyone's attention to it if that needed to be clarified and you wanted it spelled out or how you wanted to proceed there.
Well, and I did send an email out. Of course, I realize emails are not legal documents, and I understand that. Oh. The attorney and firm will not be obligated to continue representation once the cap specified in the section 4 has been reached.
Okay,
And
and it just caps, it caps attorney services at the attorney rate, and it doesn't address any kind of legal assistant or paralegal services. So if you want to
it
specify
says with
that,
developments such as the discovery of new facts, unforeseen legal items, changes in the law, or changes in the adverse party's position regarding case yada yada yada, that is initially believed to be fairly simple and become complex and require much more time and expense than originally anticipated, notwithstanding, client has approved up to a total of 20 hours of attorney services at the attorney rate of $250 per hour. Nothing in this agreement precludes the client from considering and authorizing additional attorney fees. We don't pay a general retainer. We don't pay advance fees or anything of that nature. I mean, we can, that's what we're looking for. Define that better if you think it needs to be defined better, but in the email that I sent out, let's see. I was reviewing the contract the attorney sent before placing it on the agenda and wanted to make it abundantly clear that $5,000 cap is in place, whether the amount is an attorney at $250 per hour or paralegal at $90. The total allowed expense is $5,000.
okay,
I'm glad to see that they can do work for ICAP if offered by ICAP to do so. They do acknowledge the contract with $5,000 cap. I do want to point out that on page 4, paragraph 5, included below that the $5,000 limit will also include any additional fees and costs. The contract does point out that the attorney will communicate before incurring its costs. The board will determine the need, if any, at that time. And he writes in there that the attorney will not incur transcript expenses without communicating with the Jefferson County Sheriff and confirming the need for said transcripts.
okay. Well, do you think that do you think that the contract, I mean, I think that maybe it should be further clarified if there's a specific dollar cap, but if you feel comfortable with it, then
I just want to make sure that everybody is on the same page, whether it's the board of supervisors or whether
Yeah.
it's the attorney or whether it's Bart, that there's a $5,000 cap.
right.
However, we need to express that.
Well,
That was a motion.
we don't spell out the 5,000, but it says 20 hours at 250.
Mhm.
So do you think we should have the 5,000?
And this is not, this kind of like parsing. I guess the only thing that I was looking at is it says the attorney rate, but then there's also a legal assistant paralegal rate. So I guess I was questioning whether you were saying capping all expenses or again, so that was my question.
Well, my intent of my amendment to Joe's motion was it was to be a flat cap.
Okay, well, maybe, and so I feel I can include that and then I can send any, the changes that we make based on our discussion today to Skylar, and then maybe he will get back to us when it's convenient to him and let us know if that is not necessary or what his thoughts are.
And my understanding, and I had a conversation with Bart, my understanding is that we hired Mr. Thomas to do the administrative investigation. So the transcripts, the recordings, whatever would be needed at that point should be covered under the $3,500 fee that he's charging.
It does say that fees, costs, or expenses for workforce solutions would be paid separately by the client, so,
Yeah.
and not covered herein. So, yeah, that's separate.
And so I think my opinion is, and it's just an opinion, my opinion is, and I have expressed this to Bart, that he's to oversee the process, but wouldn't actually be involved in I don't want to say it, the nitty gritty of the investigation, because that's what we hired Mr. Thomas for.
Yes, yes, for sure. So, and we don't need it, and that's a separate, sounds like that's a separate agreement, so we don't.
I will readily admit, I have not seen an agreement from Mr. Thomas. And I'm hoping. Did you get an agreement from Mr. Thomas?
I have one, yes.
Okay.
Can I talk now? Are you done or?
It's up
Can
to-
I interject?
It's up to Adam.
I have some problems with on page 2. What you inserted in there.
Got it. Yeah,
The firm will consult with the county attorney prior to representing the client or its officers in any filings, hearings, proceedings, or activities. That. Why should he be included? There's client privilege, I mean,
right.
between the client and them. Why should he be included in this?
Well, so, and that's kind of why I included this big paragraph here, because, so first of all, and the client, I think, is Jefferson County. Right?
Yes, he
So
says.
that's what he says here. He says the client's Jefferson County, and then he says that, and then later he says that there's an attorney-client privilege and confidentiality between the sheriff's office and the firm. And so I just wanted to clarify that it's Jefferson County as the client, so you guys hold the privilege. My understanding, and Bart, correct me if I'm wrong, is that the reason why Skylar was being hired was to provide legal counsel and for his guidance, and not that the proceedings were going to, not the confidentiality of the proceedings, I guess. Also, under Iowa code, the county attorney has specific statutory duties, including like representing the county and its officers in any legal filings now and any proceedings in front of the court. Obviously, Skylar is being hired to assist with some oversee or, assist or represent the
But he
county.
was hired 2.5 weeks ago. It was approved by the board according to Iowa code
Yeah,
because of the conflict. Do
absolutely.
you remember that code section?
Yes, absolutely. Yeah.
And why would you insert yourself into another attorney's contract when there's a conflict?
Well, just,
That's the issue right
Got
there.
it.
Let's not cloud everything, all this other bullshit.
Let her finish, Barstow.
Elizabeth,
oh,
no,
it's okay. Yeah.
they approved it according to Iowa code. It
Yeah.
was signed last May by the governor.
Right. Yeah,
There's-
no,
Whether there's a
absolutely.
conflict with the board or another public official. And they agreed 2-1.
Right.
There it is. So there's a conflict.
Yes.
They agreed with it. But why would you insert yourself back into a contract with another attorney? That doesn't make any sense. Why would we go to all this trouble
Mhm.
If you let her
And
finish,
do
let her finish
this
part.
to
Might
keep
make
the
sense.
conflict away from your office?
Right.
But you just cloud it with all this other crap.
Okay, I understand. And I guess I don't understand why you're so upset that I'm trying to clarify that statutorily.
This contract with Skylar's been out over 2 weeks.
I have not seen it.
Well, that isn't my fault.
Our office hasn't seen it. I mean, it was just given to me on Monday.
You had to know about it.
I had no idea how would I
Because they
to know about
approved it on the 8th.
This contract?
They approved to hire Skylar on the 8th.
Absolutely, but I
And you
hadn't
knew damn
seen.
well there was gonna be a contract out.
But the county attorney has specific statutory duties, including representing the county in all legal actions. We
What legal
can't,
actions are you talking about?
I'm saying
What
if there,
legal actions are you talking
I'm
about?
saying-
You're clouding the whole thing.
I'm not
Yes,
cutting the
you
whole
are,
thing,
Elizabeth.
Bart. This scope of services includes representation in any
This was
courts.
approved on the 8th
I haven't
because of
seen-
Iowa
okay.
code.
Well, I hadn't seen the contract, so I was just providing my edits. You as the board are allowed to do as you see fit. I just feel like there are statutory duties that the county attorney has. I tried to include that language here in the contract. Our office had not seen the contract prior to Monday. This is the first time that I'm reviewing it. I understand that Skylar has already been hired to provide this guidance and assistance. Again, my understanding, and I think the office's understanding, that he was providing legal assistance, not that every single action that was taken was going to be completely confidential from our office, because we would be
I propose
involved
we
in any.
sign the original contract from Smith Mill Law.
So it's my understanding that the board thought that there was a conflict with the advice my office might provide to the sheriff. And so that's why Mr. Linkman was asked to be hired by Bart and you guys approved. So the concern over provided advice is one thing, and that's why this contract exists. If Bart is asking for some reason, secret representation between him and another attorney boxing out the county, then I have questions as to why that conversation and any representation would need to be confidential from the
There's
county.
nothing
And
secret. It's
that-
very transparent.
Because that's-
I come to the board.
Well, and that is something that I do believe the county should be concerned about. If what this contract is implying is that you're the client, but there is going to be confidential conversations happening that you don't have access to. So, I mean, it all comes down to county liability and just making sure that there's transparency so that you know. I mean, wouldn't you want to know what kind of legal actions are going on? How would you know if your county attorney is not, like, at least copied in on those? Not saying that we're going to be opining or giving any kind of legal advice, but just so that we know, hey, this is what's going on, or hey, these are the policies and procedures that we're recommending are going to be changed. We're filing something in the court. I mean, the scope of services is broad. If you want to if you want to limit the scope of services, I guess that's one thing. But if he's going to be representing the sheriff's office in any actions in court, that's where it kind of interferes with the statutory duties of the county
I think you're getting
attorney.
ahead of yourself.
The
think you're
scope
getting way
of,
ahead of yourself.
Bart, the scope of
No, you're
services
getting way
I
ahead of
am
yourself.
responding directly to the scope of
No.
services in this
And what
contract.
confidential information are you talking about?
I don't know.
Because employee records are not going to be talked about.
I don't know, Bart, but if there is a confidentiality between the sheriff's office and the firm, there is a big problem with that.
Why?
Because
Why?
the county attorney,
Why? Do you have to know everybody I talk to and what I talk to them about?
Bart,
What is the issue here?
do
Elizabeth?
not care. I do not care personally. I don't want to interject in anything. I'm just saying, if this were to go forward and the scope of services does indicate that perhaps the firm would be
If there
representing
was
the
something
sheriff's
you needed
office.
to know about along the way, you'll be told.
That's
But
why
you
I'm
don't
saying,
need
and-
to
but
insert
that is
yourself
what
in
I-
it because they already determined there was a conflict by Iowa code.
I have
And they
no,
agreed to hire his firm.
absolutely, but this is the contract. And so as the county, from the county attorney's office, we're going to be reviewing the contract. I don't understand why there's a concern there. We're protecting the county's interests and make
What is the
sure that
concern,
there's nothing, that
Elizabeth?
there's
What is the actual concern?
the
What
law.
is what
The
about
law
the law?
is the concern. That's
What
why I'm
about it?
including the,
You are inserting yourself after you got removed from it. They voted on it.
that's
And
fine.
you're upset and you want to put yourself back in the contract league. Now, you know, we can talk all day. You can delay this again another week.
And I don't
it's-
have to
and I-
sign the contract either.
Well, I guess you don't.
That's right. Now, calm down here.
I feel very uncomfortable with the tone of this meeting.
My
Is there
concern
some way that we
Is
can tone
that
it down?
the attorney, Mr., how do you pronounce his last name? From Smith Mills Law Firm states in his original contract. It is a written attorney-client fee agreement. We, Smith Mills Law, will provide limited legal services to Jefferson County. Not to you. We are the client. County is the client. That's what he's stating. That's not what she said. It's not what I said. Our motion, when we passed this, was to cap it at $5,000. This has grown legs for whatever reason. It says the Jefferson County Board of Supervisors retains attorney Skylar J. Niffman of the firm to provide limited legal representation and services for the Jefferson County office. We retain him according to his contract. He wrote that.
And there's a reason
Sure.
he's doing that, because of Henry County.
Well, that may be fine, but it names us as the client and that he is representing us.
Okay,
He says so. And so all I'm saying is that the client, this is what he's saying, us, agrees that the firm and its attorneys will exercise independent professional judgment and will provide the Jefferson County Sheriff's Office with advice and counsel without interference. We didn't strike that. We're not disagreeing with that. But he's saying that we, Jefferson County, are agreeing to that by signing this contract. Elizabeth, insert in here Iowa Code, engagement of outside counsel pursuant to this contract by the Jefferson County Board of Supervisors under Iowa Code Chapter 80F is limited to representation of the Jefferson County Sheriff's Office as identified below. She's just simply saying that it's limited to this particular set of circumstances. Contract does not restrict or relieve the county, and the key here is or relieve the county attorney from engaging in any of the statutory duties imposed on him by the virtue of his office. So we're just simply saying here is that he's still obligated to defend us. He, just like he's obligated to be involved in a current case that we've got going on, even though ICAP is running the case. Same thing would apply here. If a circumstance, I'm not saying that it will or that it's imminent, I'm just saying that if circumstances were to dictate that ICAP had to become involved, he would still be involved and would be kept apprised of everything that's going on. And if Mr. Limpman was the one that ICAP chose to pursue or whatever, that's all well and fine. That's up to ICAP. It goes on to say that including but not limited to enforcing and prosecuting state law or county ordinances and appearing for the county in all cases and proceedings in courts of the county in which the county is a party. That there's nothing there that indicates anything other than what the responsibility is, which is what he currently is doing in another court proceeding.
And that language is taken directly from the code.
Right. So the other thing, and that you're concerned there, Joe, when he talks, the firm will consult with the county attorney prior to representing the client or its officers in any filings, hearings, proceedings, or any activities in any federal, state, or local courts. We should absolutely want that. We know ahead of time, because then we're gonna, at this point in time, if it gets to that point, I'm anticipating that we're on the phone to ICAP. This was the understanding that Mr. Limpman is not going to handle any of that. That's the reason that we have the errors and omissions and the law enforcement clause in our insurance. They handle that. That in response, and he's doing his what's the word I'm looking for? In performing his duties and responsibilities, he's covered. And this is what he's doing now, trying to ferret all of this out with everything that's going on with some personnel matters. There is, if I'm not mistaken, some criminal matters that are involved in it as well, which is not being handled directly by his office nor by this individual. We hired an outside entity to do the administrative investigation. Specifically for the purpose of, so that if in some point in the future, if Bart has to administer discipline, he has been insulated, so to speak, my words, not, okay, from the process that led up to this point. So all we're saying here is that if it's going to go to court, we want our county attorney involved in it. We want ICAP involved in it. And the firm will also copy the county attorney on any communication between the firm and its client or its officers. We're going to have access to that stuff. ICAP's going to want access to it.
If it goes that far.
Yeah,
So-
if it goes that far.
So why include them now. If we get that far, then they will be brought up to speed on everything.
If it's not-
Exactly.
I guess,
if it's not written out, then there's no requirement in the future to provide it, because there's nothing in the contract that we signed that requires a tap.
and I guess if you want to limit the scope of his services, you could do it that way, but I mean, I guess why do that? Just allow for him, if necessary, to make sure that the county attorney is apprised of these things.
And I've also asked Bart to make sure that both Mr. Thomas and Lincoln Howard keeps Christie and Darcy informed, because there are HR. And they need to be, well, Christie's sitting there, but they need to be apprised of what's going on as well. Because it is an employer-employee relationship issue. And, you know, I mean, Bart keeps personnel records better than anybody as far as that part goes. That's not the issue. I'm just saying that HR needs to be apprised of what's going on, and I know he's been in communication with Chelsea. So, okay, and so he's spoken to her. To me, there isn't, for me personally, you can't require something after the fact if it's not in the agreement. That's
But the whole thing is, Lee, I haven't been insulated the last year and a half. And it involved an employee issue, a discipline issue.
right.
And I wasn't insulated. Now I'm up against another similar situation. And obviously the county attorney's office is gonna argue against me every step of the way.
That's.
They are gonna argue against me. They're not in my favor, and they're never gonna be.
But the question is this, though, Bart, based on the representation contract that he submitted, we are the client.
There's a reason for that,
Yes.
because of what Henry County did to his law firm.
Well, I don't know what Henry County did to his law firm, and I can't be held accountable for what Henry County does. I can only be held accountable for what we do. And for me personally, I don't see anything here. It spells out what his scope of services are. He spelled it out. There is, I mean, it's, none of that's been struck. We hire the attorney to represent the Jefferson County Sheriff's Office regarding administrative investigations and potential disciplinary actions of 2 employees of the Sheriff's Office. Representation includes administrative investigations, related investigation activities, including witness interviews or interviews of officers as defined under Section 80F, conducted under Iowa Code 80F.1, and any pre-discipline hearings or proceedings that may arise, and other related discipline meetings, hearings, or proceedings. Representation includes participation in the administrative matters review of evidence and policies and oversight of the administrative investigation, Workforce Solutions LLC. Representation will include providing advice, recommendations, guidance, and counsel through the completion of any administrative investigation and proceedings, if applicable. Representations may include other representation activities, including drafting or revising documents, correspondence, research, communicating with the employee's legal counsel and or employee representatives, communicating with others involved, including activities attorney believes are necessary in his professional judgment and discretion. Attorney and firm will not be obligated to continue representation once the cap specified in Section 4 herein has been exhausted. There's the scope of services. Nothing in this agreement changes what he put in there for his scope of services. And when we sign this document, if we sign it, those scope of services is what he's saying he's going to do for you, and you've accepted those scope of services.
Okay.
So, and it says the scope of this representation is limited to pre-suit activities. Okay, which I agree 150% with him, because at that point, ICAP is going to take over. But the information that he's gathered, okay, if a lawsuit arises, Okay, his activities is limited to pre-suit activities and does not cover litigation or appeals of any kind. We have to have, as the client, access to that information to be able to defend ourselves in any action that may
Access
be
to what
brought.
information, Lee?
Huh?
Access to what information?
All of it.
All of what?
I don't know, whatever he says, correspondence, research, communicating with employees, legal counsel, employees, representatives, communicating with others involved, including activities attorneys believe are necessary in professional judgment. The scope of activities, if he has all this information, he can't walk away from it. We're the client. And if we have to go to ICAP and hire, I don't know, him maybe, I don't know, but attorneys to represent the sheriff's office and the county in a proceeding, all of the information has to be available to be able to litigate it properly. That, to me, that's common sense. And what he's doing in here is he's simply making sure that, as I read this, that representation will include providing advice, recommendations, guidance, and counsel. He's protecting you. By this, and we're saying yes. Representation will include providing advice, recommendations, guidance, and counsel through the completion of any administrative investigation and proceedings, if applicable.
And it's limited to pre-suit activities.
Yes,
There you go.
and we agreed to
And
that.
why wouldn't the original one be signed? I don't know why we have to put additions to his contract and involve more people.
We're not involving anybody. What we're saying here is that he has a statutory duty. We as the client have a right to know.
I have a
And-
duty too as the sheriff.
Yes,
Yes.
right, but we are the client. And so all we're saying, or at least what I'm saying, I don't put words in Joe or Susie's mouth. What I'm saying is that for me, we're being represented by the client. We're the ones that are going to get sued. And we have to have this information available to us to be able to defend the county and to defend you. ICAP
How are
attorneys
you
are
getting
gonna have
ahead
to
of
have it.
yourself?
It's just what I just said to Joe. You can't come back after the fact and demand something that you didn't have in a contractual agreement. That's all. I can't come back and demand that he represents you in the scope of services if those scope of services aren't listed. He doesn't have a requirement to provide those services if it's not listed in the contract. We didn't strike those services, nor are we asking those services to be struck. It's very clear what he's going to do for you or on behalf of you. And we agree with those scope of services. And it says, nothing in this agreement precludes ICAP assigning defensive claims on behalf of the client to attorney, meaning that.
So he's got a scope of services.
Yes,
Why would he consult with the county attorney's office if he has a scope of service?
He doesn't have to consult, he just needs to let us know.
That's in there.
because-
That's, you put that in there.
Well, prior to representing the client, for sure, because we have I will not say we, I will say the county attorney has a statutory duty to represent the county and its officers and any kind of proceeding in court. So that's why I was just saying he has to be consulted because that's his statutory duty. Now, again, maybe, like you said, we're getting ahead of ourselves, but we just need to have that in there. If he is going to be representing the sheriff's office in any kind of proceeding.
It's pre-suit activities.
he
It
says.
does
here
not cover litigation or appeals of any kind.
In his contract.
I mean, that's very clear.
In his contract, he states that he wrote this. Until client and the firm make a different agreement in writing, this agreement will govern all services the firm may perform for the client. The firm shall diligently represent client and will conform to the rules of professional conduct of the State Bar of Iowa and duties of attorneys. And the client's duties that we agree to be truthful with the firm, to cooperate fully with the firm, to keep the firm informed of all relevant information and developments. Shouldn't that be a two-way street? If we're required to provide to him and keep him informed of all relevant information and developments to abide by this agreement, obviously he wants his bills paid too. I mean, all we're simply saying here is that I think what you're having concerns about is the firm will consult with the county attorney prior to representing the client or its officers in any filings, hearings, or proceedings or activities in any federal, state, or local courts. Well, we need that confirmation and conversation to have the information to ICAP, whether ICAP hires him or not, or somebody else. Okay, we need to be consulted in that regard. I mean, and that's all it's saying here is that any activities in any federal, state, or local courts.
Myself, I think you're trying to read too much into it.
I'm just reading what's written.
Yes, but he is hired to oversee the other attorney. So he shouldn't be making any decisions or anything, correct? Am I wrong?
Hired to oversee what other
This
attorney?
Lincoln is to make sure everything is going correctly. He's not going to be doing any depositions or whatever. Am I mixed up?
Yeah, you are, because he states in here that there could be transcripts and stuff. He would notify us prior to doing those transcripts.
If the other attorney is doing
No,
that.
that's not what he's saying here in the scope of services. I just read you what his scope of services
Yes,
are,
yes.
okay?
But I thought he was hired to oversee the other,
What
Yeah.
other attorney?
the workforce solutions, is that correct?
So he's not an attorney, he's just the investigator. So,
That's-
but then Mr. Linkman would be, I guess, overseeing that, yes, but then also providing guidance to the sheriff's office about how to proceed after that investigation is complete.
That's my take on it. He really wouldn't be actively doing stuff. Am I reading it wrong?
Well, then he will never have to consult with the county attorney. Right? I mean, we have that in there just to protect the county. And then also, honestly, I mean, the county attorney does have some statutory duties. He can't be completely boxed out from performing those statutory duties.
I mean, you're right, Joe. He's saying here it includes administrative investigations, related investigation activities, including witness interviews, interviews of officers as defined, conducted under yada yada, any pre-disciplinary hearings or proceedings that may arise, and other related discipline meetings, hearings, or proceedings. Representation includes participation in the administrative matters, review of evidence and policies, oversight of the administrative investigation, which is workforce solutions that you just referenced.
Mhm.
Representation will include providing advice, recommendation, guidance, and counsel through the completion of any administrative investigation and proceedings if applicable.
Sorry, I was just gonna say, if I may, Lee, I could give you an example that is pretty timely. So let's say that, and obviously this is very theoretical. Who knows if we're gonna get to that point, but this is included in the scope of services. If there is a complaint to the ICRC and then the EEOC, right? And then there are any hearings or any responses that are generated by Mr. Linkman, you would probably want to be notified, I would imagine. And that would be a pre-litigation hearing or pre-litigation responses that would happen prior to any lawsuit being filed.
And we've had those filed 3 times.
Yes.
On 3 different employees since I've been here. And so, and that would not be a reflection upon Mr. Lippman, or for that matter, John Thomas. I mean, they have their right, to do that. It doesn't necessarily mean that it would go, I mean, it can, I agree with you on one level, we're getting far afield here. The scope of services are laid out as what he's going to provide. And it goes through the investigation process, and to make sure that he's covered, that there aren't any missteps. And that at that point, he's documenting all of that. If we end up having to be defended in court because an employee brings a suit and he ends up having to be defended in court, we need that information. And if I'm not mistaken, and maybe I am, but there's certain aspects of that investigation that would be, what do you call it in legal terms, that you have to disclose it or whatever?
Discoverable?
Yeah, is it discoverable?
Yeah.
So,
Why would Workforce Solutions already have that information? Are they not gonna be able to bring it forward? The first attorneys that we use,
They're not attorneys. Are you saying Workforce Solutions?
Workforce Solutions.
Yeah, it's not he's not an attorney.
But his information could be brought forward.
I don't know what that contract looks like. I don't know if that information is being disclosed to you guys or what. I mean, I have no idea. Yeah, so I don't know.
it read that it was, that it should be an outside entity that conducts the investigation. By, Chauncey felt that that was the proper way to go as well, and Bart wanted that outside investigator.
So there's no contract with this Workforce Solutions or
And
anything?
Bart has a contract.
You, okay. And that information would be brought forward if we move on?
Have you guys seen the contract?
I have not, no.
Oh, okay. Are you not are you entering into the contract? Who's entering into the
I
contract
assume
with
the
them?
sheriff's office did.
Who's paying for it?
I don't
Who's
know.
paying for it?
I don't know. I don't know.
Okay.
Who's paying for it?
So.
Who is paying for it? Is it your office?
Yes.
Oh, okay.
So it was $3,500, as I recall, right? And so, and I'm assuming the interviews and so on and so forth, and then he will make, I don't know if he makes a recommendation or just provides you that information from the results of his investigation. And I know,
I think he's still gathering information. Skylar, John, myself, we don't have all the information yet. That's being withheld.
right,
Everything, witness statements, videos, everything's being withheld.
okay,
We don't have it.
who's withholding it?
Well, Wapco County Attorney has it and Jefferson County Attorney has it.
Okay,
We outsourced it to Wapello, because, we're conflicted and so we couldn't handle those criminal charges. It was investigated by the state troopers, I believe,
Iowa State.
Iowa State Patrol.
so. We beat this.
I think this other paragraph ought to be deleted. Firm will consult with the county attorney prior to representing the client or its officers. The entire paragraph should be deleted.
And again, I included that just because of the county attorney's statutory duties pursuant to his office. If there's going to be no representation, then I guess it won't have to be invoked, but you would want that just to protect yourselves so that you're copied on
She
all
just
the
said you
relevant
had a conflict with
information
the case.
and then all of any filings or anything of that nature, so.
That's where I have the problem with this second page paragraph that's inserting.
Well, would you
So-
prefer to limit his scope of representation or just allow him to copy the county attorney on some of these things and consult with him just because, again, it's by law, the county attorney has specific obligations by virtue of his office. So I guess I don't understand why if that's not needed, if he never needs to consult him because he's never going to be representing anybody in any proceedings or activities, then great. I don't understand why you wouldn't want to include that just to protect yourselves so that you are given notice of these things
Oh.
and you have all of the information.
I don't know what you're protecting yourself from.
Litigation that could potentially occur sometime down the road. Isn't that why you get an attorney? I mean,
Well, I mean, yeah, I understand. And that's the issue because we're the client, meaning the county. Of course, the county is gonna be sued irregardless, but, I mean, I guess I don't know that he actually would be representing the client, which would be us, in any filings or hearings. Um, does say representation does not include Jefferson County and any other matters of proceedings.
We're ready to move on, you think, Lee?
Well, I'm gonna ask Elizabeth a question here.
Okay.
Client agrees to authorize firm to communicate with client regarding this matter via email and understands that email communications may not be secure or private. Client understands that communications conducted on all computers and networks may not be confidential. Rest of that is billing. So, yeah, we can move on. I mean, you make a decision one way or the other, how you want to proceed.
I unfortunately have another hearing that I have to attend to, so if you want to just let me know what you decide about the contract, if you want me to include that $5,000 cap on all legal fees, then I can do that. Again, I never heard from Skylar, so I don't know, I haven't gotten his take on these edits.
He sent an email.
He did
Yeah,
just now. Was it in response to my email?
I suppose.
Okay, I just
Included you
didn't.
and Lee.
Okay, great. Yeah, I'll see if I can find it and then we'll see what he, what are his, did he have any specific thoughts, Bart?
I read the email.
Okay, okay.
You want to make a comment about what you're looking at there or not?
Oh, I'm sorry. I was gonna check my email to see
Oh.
what Skylar said. I apologize.
No,
That's what I was
didn't know if
doing
you had
here.
a comment
Nope,
about that or
nope.
not, so-
I just was logging into my email and I
Well, I
apologize.
guess I
Okay.
just will put my foot out into the water.
Okay, to respond to your question in the Word document, the cap was for the attorney's fees. So if a pre-discipline Laudermill hearing is needed for either or both employees, it will require me to travel to Fairfield, so there would be travel expenses. Mileage is at the IRS rate. The firm's representation agreement that it enters into with other clients, including municipalities, all separate out attorney's fees from expenses. I'm fine with getting approval for expenses in excess of the $5,000 cap in advance from the sheriff or chair of the board, if that makes the county feel more comfortable. If the bill won't exceed 5,000, then that shouldn't be an issue, but obviously it isn't possible to predict, especially with this involving two separate employees. I have concerns about the additions in the paragraph on page 2 and would not be in agreement with those. I don't know if he's available to talk to you guys or if you'd like to meet him or make a decision today. Of course, it's up to you. So he's not in agreement with the changes on paragraph, page 2, which seems to be what everybody's having a problem with. So I don't know if you want to speak with him about that or how you'd like to proceed. But seems like maybe there's some more details regarding that $5,000 cap that I don't know if you.
I'm in agreement with putting the $5,000 cap figure in there.
Okay.
That's the way that was our motion. That's the way we
Yeah.
agreed to that.
Okay. All All right, it sounds like maybe there would be some travel expenses that might be outside of that. So I'm not
I
sure, and I apologize, but Chauncey's here
That
said he
should be
can.
included in the 5,000.
Well, I do too. I don't.
So
I've
5,000 is
expressed
5,000.
Okay, I'm so sorry. I'm sorry. I
That's
didn't-
fine.
it.
That's
But
fine. We
Chauncey can
understand.
take over if you have any other questions.
You know, if he's-
Just let me know. how you'd
Thank
like to
you.
proceed with it.
Absolutely, but if he spent 10 hours at his rate, and he had other expenses, then it comes in, like he said, it comes in less than 5,000, we're good. But I can't imagine, quite frankly, why we would use over 20 hours to begin with, but I think you're right, the motion was to cap it at $5,000. I think the intent of the board was to cap it all the expenses at $5,000, so I agree, we need to spell that out. As far as the second page paragraph is concerned, I'm not gonna lose any sleep on it over one way or the other, except I think it's important to note that we are the client. And that there exists and must exist an attorney-client privilege. Now, that's not what this second paragraph says, and so, okay. I'm not sure why he has an objection to it in terms of, and we need to be apprised of anything if it's going to federal, state, or local courts, in my estimation.
Which is all pre-suit activities. It's nothing beyond that. He says that in there. I mean, I think you're getting way ahead of yourselves on that thing.
But if I-
And this
okay,
does involve confidential employee records.
Well, I
And that's
understand.
something that you can't be privy to.
Oh, yes, I can.
I don't think you can.
Yes, I can. Absolutely. The handbook's very clear on that. Management. But I'm not going down that road at this particular moment in time because that's not the issue. If you want to strike that paragraph, she's got to take some things back and make some adjustments anyway.
I would like to strike that paragraph. That's my thought. Do we need a motion to do that, or?
At this point in time, I'm so damn confused, I don't know what we need.
I would be
So I
willing,
think what I think the motion should be, we go. Okay, so you want that paragraph taken out?
I would like that paragraph
And we
taken
want
out.
the contract to specifically spell out that it's a $5,000
Yes.
cap on all fees and services.
That is correct. That is the way the original motion was. That's the way I expect it to be.
Okay, those are the only changes. You know, Mark has indicated that, you've indicated that, Mr. He needs to have a simpler name to pronounce, indicated that. Skylar, I apologize, Skylar, but I'm gonna use your first name, it's easier for me.
Yeah.
Okay, so. What we're asking the county attorney's office to do is revise the agreement by removing the second paragraph and defining all fees and services under the $5,000.
Yes, that's what my motion is.
Any further discussion? Susie?
Yes, sir.
Oh, I thought she was sleeping.
Joe?
I heard some snoring a while ago, and I didn't think it was Abby.
Yeah, I'm pretty sure she is. Anyway, let's go on, proceed.
So do you got any, you want to say anything? You got any comments?
Not at this time.
Okay. So the motion is to strike to strike the added paragraph on page 2 of the contract and define the $5,000 cap as pertaining to all legal fees and services.
Can I make a comment on paragraph 2?
Sure.
Paragraph 2 is to keep the client informed as to the scope of services and what's going on. My understanding that the sheriff requested outside guidance from an attorney other than me because he felt like there's a conflict, that he has a conflict with the advice given by my office. That outside attorney was approved by the board, Mr. Lincoln, to provide that guidance to the sheriff. Now it feels like, in addition to outside guidance, the sheriff is requesting essentially that the county be boxed out from any decisions, advice, and figuring as to what to do in this matter. I do have a concern that getting rid of paragraph 2 essentially ostracizes or carves out some kind of confidential and secret from the county representation, and I don't know why that would be a necessity. The paragraph only states to keep us, county, informed as to what's going on, not to require us to approve or to provide input. So if that's stricken, I'm concerned as to why. I don't know why you would want to have yourselves isolated from any legal things that are involving your county.
First thing, that didn't come from Bart, that come from me, that motion did.
Right.
Clarify,
I'm just clarifying on paragraph 2,
yes,
page 2 there.
yes.
So is there something in that paragraph that you're particularly concerned about?
Attorney-client privileges,
No, or it says the firm will consult,
yeah.
okay? Prior to representing.
Who is the firm? That is the Mr.
Skylar.
Skylar Lincoln?
Yeah,
Okay,
well, his law firm
Smith Mills.
yeah,
will consult with the county attorney prior to representing the client or its officers in any filings. Now, Bart's right when it say that it is somewhere here, I don't know, that, scope of this representation is limited to pre-suit activities. But I guess my question is, if we don't have, if we're not able to consult, if we don't have, as the client, we should be able to consult with the firm prior to any filings or hearings. Not that he's going to be involved in it, because he's limited to pre-suit activities, but the information is stuff that he has that may be relevant to our ability to defend ourselves. I don't know if that's not in there, if he's obligated to provide it. We are the client, he says so. So the client has a right to that information. I don't know, does it have to be spelled out?
Should, yeah, if it's not spelled out, where do we enforce that right?
Well, I don't know, because we're the client. Anyway. So what in there is it that bothers you besides the whole thing?
you summed it up, the whole thing.
Specifically,
That's my thoughts.
yeah,
If you
okay.
don't like it, that's
No,
fine.
no, it's not a question of like or not like. I just would like to know
I just,
where your concern lies.
I'm afraid there might be some influence on something. Maybe I'm wrong.
Well, I think maybe we need to meet with the Skylar. Because where I'm at is, I personally want to make sure that we have access to all of the information. If something, and I agree with Bart that, it's pre-suit activities that the firm will be involved in. But some of that information we may need if it moves beyond quote pre-suit activities.
What
And
what the board could do is it could approve the drafted amendment to the contract with the addition of the $5,000 cap. Authorize the chair to sign and send to Mr. Lincoln, and if Mr. Lincoln has an issue with it, then we can set another meeting. He can either sign it or you guys could have a conversation with him.
The last sentence in this paragraph. The firm will also copy the county attorney on any communication between the firm and the client or its officers. The way that reads, they're gonna add the county attorney to that.
Right, as a CC, just provide information.
Yes, yes.
Not consulting, just not keeping it confidential from your lawyer.
Everybody's looking at me.
Well, so Chauncey, repeat what you just said about signing it so that there's a contract.
So the board could approve the amended contract with the addition of the $5,000 total cap. Authorize the chair to sign. Elizabeth can make the necessary modifications, send it to Lee, Lee can sign it, send it to Skylar, Skylar can review it. And if he thinks that there's a necessity to have further conversation, he can indicate that to the board.
I think Joe made a motion to take out that paragraph. What happened to
Yeah,
the
that's-
motion?
The motion's on the table yet.
But you don't have a second.
Nope.
Okay, Joe, repeat your motion.
My motion was to eliminate that this paragraph on page 2 that my copy's highlighted in red. And to add the wording of $5,000 cap on everything,
All services and fees.
all services and fees. Okay.
Susie, did I sent that to you in the email? Didn't I?
Yeah, you did.
Okay.
You did.
Did you have a chance to review it?
Yes, I did.
Good.
So basically, Joe, all you want to do, all your motion says is you're going to make sure it's firm with that $5,000 cap,
Yes.
and that's it.
Yes.
He wants to remove that second paragraph in red on page 2.
Hers might not have showed up in red.
Oh, okay. The second paragraph where it says the firm will consult on page 2.
I don't have that.
Go to page 2. The firm will consult the county attorney prior to representing the client or its officers in any filings, hearings, proceedings, or any activities. Yada, yada, yada. Have you got that paragraph?
So that's what your motion wants to, you want to include that in your motion?
Yes, to eliminate that paragraph.
Hurry, we're gonna be floating here in a minute. Sorry, but we will be.
Do you understand what I was talking about, Susie?
Yes, Joe. I do.
Okay, thank you.
So is there something that you would insert in its place or not?
No.
Not this time. I wish I could be there with you guys. This would be easy. And I'm sorry.
I didn't catch what she said.
I said I wish I could be there with you, but I
Oh.
cannot today. I am sorry.
She's roller skating in a buffalo herd.
You mean if I was there?
Well, no, that could be too. All right, so, the record, I don't have a problem with that paragraph. If there was a way to rewrite it that might The last line, is that a problem, Joe? The firm will also copy the county attorney on, again, I mean, if the firm was to copy the client, which is us, you see what I'm saying?
Mm-hmm.
Why would we not want our attorney? It's not a secret, is what I'm saying.
Shouldn't be a secret.
So is the county attorney going to be having any say-so in any of this, or are they just gonna sit back and see the proceedings and stuff? Are you gonna try to interject and have an influence over this?
In what capacity? That clause says that the communications CC my office. So I represent you, and I represent the county. I am not gonna opine as far as what the future holds with this, hopefully nothing. So, honestly, I think we're making a mountain out of a molehill here.
I agree with you, we are.
So, yeah, I don't know why you would want to intentionally, box out.
Why would you want to be included? I can turn the question back to you.
Why would I want to be included on legal matters involving county, Joe? Because it's my job to make sure that this ends up in the best possible way for us.
Okay, there's a motion out there. Is it gonna be a second or not? We'll see.
Well, what I would like to do is if you're agreeable, is to amend your motion to prove it other than having the $5,000 cap cover all legal fees and services. And then authorize the chair to sign, and Mr. Schuyler, that's not right, the firm review, which he's expressed some concerns, given us then the opportunity to have a conversation with him to see if there's any changes that we can make to that, but there's a contract in place so that he can provide the scope of services that he's listed. And and at that point, we can have a conversation and it may get struck altogether. But if he has some concerns or if he sees a way of doing it differently, I would like to know what that is.
I'll accept that amendment.
And then, and it may be that it ends up ultimately getting struck. I don't know what Mr. Scott, I don't know what the firm's schedule is like. I'm more than willing to have the conversation, and there may be something that would satisfy all parties involved, and I'm perfectly willing to hear what that might be or what it would look like. But I do think that we should have any information that may be pertinent. And I agree with Bart 150%. This is a pre-suit contract. But we're not saying that the firm would do any filings or hearings or proceedings or any activities in any federal, state, or local court. What we're saying is that we need the information before those filings occur, whether ICAP's doing the filings or whether we're doing the filings or whatever, not indicating that that the firm is going to do that. And we're not expecting Smith, to do that. That's not what's being said here. And I would not want to put anything, I don't want to put words in his mouth or anything of that nature. But if he's going to communicate with us, meaning the client, I have an obligation as well to protect the county, and information that we receive that might be relevant. If we're involved in a lawsuit, I have to give to the attorney's office.
Point well taken.
And I am more than happy to sit down with the attorney and rewrite this to just, you know, to hear his concerns and maybe get a more definitive understanding of what it is.
That would be no more than fair, his input too.
But at the same time, at least there would be an agreement in place that would allow him to proceed. If he chose to do so, he hasn't signed it yet, so he hasn't accepted it. It gives us the opportunity to talk. It gives Bart the representation on the scope of services that's laid out that he needs. And we can meet whenever is convenient for you and for Skylar. Tomorrow wouldn't work unless it was in the afternoon, but
I thought he was out of the office.
well, his email said till the 26th, you're right, yeah. But, you know, whatever works.
You might be able to just call in.
Yeah, well, again, I don't know what he's, all I'm saying is that it gives the opportunity to move forward. Him and us to have a conversation specifically regarding that, or any other questions that the board may have, or that Bart has. It gives him the contract, the scope of services can be performed or initiated from our perspective after we amend it on the $5,000 cap on all fees and services.
So just so I'm clear for the motion here, the motion is to approve the contract as amended with the addition of and I'm quoting
No, they
here,
don't need
5,000 cap on all services and fees.
They don't send them
to
to
that
us, they send
provision.
them on Facebook.
And then to authorize the chair to sign.
Yes, that's my amendment. And then in that, we can also add in so that it's on the record to meet with the firm to further discuss this paragraph. Paragraph
Sounds
2
fair.
on page 2 contract, which he has expressed he has concerns with. And we may amend that then based on conversations that we have with him.
Getting all this down. I agree to it.
So that's just a second. Okay. And then Bart, will you have an opportunity to see what his schedule is like?
Yes, I can check with Skylar.
Thank you. All right, so we have a motion and a second. Susie, anything?
Nope, no, not this time.
All those in favor say aye. Aye. Opposed, same sign. Okay, so will you have, Melissa,
I'll have her punch in that $5,000 number and get it to you, hopefully before noon.
okay, and then we'll meet with Skylar, I'm sorry, with the law firm. I don't know why I have so much trouble with his last name. To discuss him changing his last name and also paragraph 2 on page 2. And he may have some, like I said, he may have an idea or, you know, express what his concerns are or whatever, and so we'll have an opportunity to make a decision on it at that point.
Okay.
It doesn't preclude removing it, it just gives us an opportunity to meet and discuss it with him and
Discuss
see what,
Yes, okay.
all right? There's nothing else. I would entertain a motion to adjourn.
So moved.
So moved, second.
Oh, I'm sorry. Better get Susie's name down there so we know she was here.
All those in favor say aye.
Aye.
Aye, thank you. I have to go.
Thank you,
downstairs,
Susie.
folks.